Good afternoon, ladies and gentlemen, and welcome to this webinar on complying with the GDPR. My name is Alan Calder. I'm going to be your host today. My background is in cyber compliance. I wrote a book on information security about 20 odd years ago, which led indirectly to the founding of IT Governance, out of which has grown a business which increasingly operates on an international basis. Our biggest business is in the UK. I'm the founder of that company, IT Governance Limited, and the publishing business continues to be at the heart of what we do, but some 90% of our turnover now comes from products related to where we started, in other words, software, consultancy, training, and all the kinds of products and services which your customers are likely to find useful. Our overall range of activities, again, as you probably know, covers the very broad range of governance, risk management, and compliance. The parent organization which we set up, GRC International Group PLC, was floated on AIM about 4 months or so ago. But the core of our business is in and around cyber resilience, data protection, cybersecurity, PCI, penetration testing, and so on. And we deliver those services in the form of consultancy, certification-related services, particularly around cyber essentials, technical security, training and qualification, software, and of course the books and tools, which is where we started off originally. I'm going to talk today about the GDPR and its impacts, and it's a perfectly sensible conversation to be having when you recognize that on their own admission, no more than between 25 and 30% of the UK's companies are currently compliant with GDPR. That probably means half of that in reality are compliant, and most of the rest are somewhere between think we're making progress to haven't really got started yet. And that probably means that quite a significant portion of your clients are in the same kind of area. They will be grappling with what does GDPR compliance really mean? How serious is it? What do we really need to do? And where do we get the help that we need? And of course, through your channel partnership with IT Governance, you should be in a position to help them answer some or all of those questions. So we'll talk about the GDPR and its impact. We'll look at the key steps to becoming compliant, the products and services that you can offer to your clients to help them get there. We'll talk about how to report data breaches, what the requirements are at the ICO. And these are quite critical because you've got to recognize that you've got 72 hours to report, and there's quite a lot of data you've got to provide at the point when you're reporting a data breach. Failure to report a data breach itself is an offense, so it's quite important to get that right. And then the products and services that can help organizations become breach ready. So quite a lot of content around GDPR compliance, data breach reporting, quite a lot of links to relevant products and services that you can offer to your clients. Of course, you'll want to get more competent around a number of those products and services as time goes on, not just from the perspective of how they work, but simply from the perspective of being able to talk to your clients more knowledgeably about them. But the starting point is to see how the product portfolio fits together around GDPR. So the logical starting point is, what's the difference between a directive and a regulation? The General Data Protection Regulation is a law when passed by the European Union. That means that it doesn't depend on member states passing laws for it to become law. It becomes law by virtue of the European Union treaties. A directive is an European Commission directive to member state governments, telling them that they need to take certain steps in order to put particular types of law in place, but is not the same as a regulation, which is a law. In fact, the UK government has passed the Data Protection Act 2018, which takes the GDPR and puts it into European law, which is, for which there are really two reasons. The first is to ensure that the various derogations which GDPR allows for, in other words, the areas in which member state governments have some flexibility to make their own decisions, are made part of UK law, but also to ensure that GDPR survives beyond Brexit as a step in the government's hope to be recognized by the European Union as having an equivalent data protection regime as the European Union beyond Brexit. The reality is we've got no idea what will actually happen beyond Brexit. So the data protection model under the GDPR starts with you and me. We're data subjects. It applies to living natural persons. So a company is not a data subject, only an individual is. And we have rights. And when we share our data with a data controller is defined as the entity which collects information from data subjects and decides what to do with that data and for how long, then we're entitled to see our data protected. So data controllers therefore have duties to us which reflect our rights, our natural rights as data subjects. Data controllers can share data with data processors, third parties with whom they have contracts. So a payroll organization, for instance, might be a processor. A CRM system in the cloud might provide a data processing platform. These are certainly areas in which, as an organization, you as a controller may have obligations. Your clients as controllers may have obligations. It's entirely possible that you as a managed service provider or service provider of some sort will be both a controller and a processor in relation to your clients. Data controllers can export data to third countries, subject to a range of necessary guarantees, and can disclose data to third parties, can even sell emailing lists, but all subject to the requirements of GDPR. So overall, data controllers are at the heart of ensuring that data subjects about whom GDPR is written are properly protected. The Information Commissioner exists to ensure that GDPR is properly enforced, and the European Data Protection Board exists to make sure that the 28 member states are applying the GDPR in a way that's consistent across the European Union, so that there is a level playing field both for clients and for data subjects within the EU. So natural persons, that's you and me, we have rights associated to the protection of our personal data, the protection of the processing of personal data, and the unrestricted movement of our personal data within the EU. And folks, if as I'm going through this, you find there are things about which you're going to want to ask questions, please do use the Q&A function in GoToWebinar, which should be in the panel on the screen in front of you. You can type a question there. Type a question there the moment that you think you want to ask it, and I'll make sure that I pick up the questions when we come to the Q&A session a little bit later on, and I will try and deal with the questions in the order that they've been raised. So data subjects have rights, and the types of personal data which is in material scope for the GDPR is personal data which is collected to be part of a filing system or intended to be part of a filing system, or that's processed wholly or partly by automated means. If you're a data controller and you're in the European Union, you have to comply with GDPR. If you're a data controller outside the European Union providing services into the European Union, you also have to comply. Data processors anywhere in the world, if they're operating under a contract from a controller, also have to comply with GDPR. And it's the obligation of the data controller to make sure that the processor is in compliance. To help you focus, there are in GDPR significant fines. And fines have to be, says GDPR, effective, proportionate, and dissuasive. Dissuasive means stop you and others from repeating the breach. Proportionate, though, means they can't be out of proportion to the breach. So if you're British Airways this morning and you're contemplating after a weekend of frenzied activity trying to contain a data breach of some 380,000 payment card records, you will be recognizing that a payment card breach is also the same thing as a GDPR breach, because payment card data is personal data, and you'll be looking at given that you almost certainly haven't been PCI compliant for a bit, otherwise if you were, you wouldn't have been breached, and absence of PCI compliance is likely to be treated as negligence, and a breach of security around personal data is going to be treated as a breach of Article of Data Processing Principle 6. You're potentially looking at fines in the upper tranche, that's 20 million euros or 4% of the total worldwide annual turnover in the preceding financial year. That's potentially where BA is today, trying to argue down from 4% of global turnover to something which they can afford, while at the same time facing a class action lawsuit that's already been mooted because data subjects who feel that their rights have been transgressed have got a right under GDPR to bring an action for financial compensation for non-financial damage which they've suffered. So you can imagine quite easily how potential damages for BA could be £1 billion or more. For smaller organizations, could be a smaller amount. If you're very small, you're looking at the 10 million or 20 million euros rather than the 2% or 4% of global turnover. So potentially very significant fines. Organizations need to be taking steps to ensure that they are genuinely compliant. And there really are 8 steps broadly that organizations need to go through. Establish an accountability framework, scope and plan the project, conduct a data inventory and a data flow audit, do a detailed gap analysis, develop and put in place appropriate operational policies, principles, and processes, secure personal data through organizational and technical measures, have appropriate communications in place, and monitor, audit, and continually improve. In other words, GDPR is a journey, not a destination. The fact that you've got yourself to a point of compliance doesn't mean that you are permanently compliant. You need to be continually improving it, recognizing the changes in the threat environment, recognizing the risks which as an organization you have that you need to deal with, and continually ensuring that the data that you've collected of customers, staff, partners, and so on is all appropriately protected. So I'm going to talk you through each of those steps very briefly. I'm going to introduce you to some of the tools which you can offer to your customers to help them tackle those particular steps. And it's likely that you'll find a customer of yours, when they're talking to you about GDPR compliance, may already be some of the way along the journey, and they can always start at step 3 or step 5 or wherever is appropriate for them, and you can introduce them to the tools which are appropriate for that step, as well as perhaps the backwards tools. So starting with the establishment of an accountability and governance framework, the GDPR requires organizations to be accountable, and that really does mean from the board down. The size of the potential fines and damages are such that boards need to be paying attention to the exposure of the organization and are expected to be paying attention to the risks to the rights and freedoms of natural subjects. So if you're the person at your customer who's in charge of the project, they need to have briefed their senior management on GDPR. The senior management needs to understand the necessity of investing time, money, and effort, and to provide real management support for a compliance project. There should be a senior manager or director who has responsibility and accountability for the GDPR compliance, and data protection risk should be added to the corporate risk register in such a way that it becomes a standard part of the organization's internal control framework. 2 simple tools that can be used to get boards and directors up to speed. There is a pocket guide available which can be purchased in volumes. You can get them in packs of 5 or 10 or 20. In larger volumes, you could have them co-branded at no extra charge, depending on the volume that you're buying. That can be a useful way to help a number of people at your clients get their head around GDPR. And there is an Ask Us service where where a client can very inexpensively go and ask questions that they want, right, without having to go to their lawyers, ask questions about how to tackle a particular issue and get an answer. It's a live, online Ask Us service, so that's available. The second step is to scope and plan project. So your client, or you might, on behalf of your client, depending on the nature of your service relationship with them, put together the project plan. So you need a project manager, you need probably a data protection officer, you need somebody who is going to be able to deal with the requirements of the DPO. And there are a number of organizations for which the appointment of a DPO is mandatory. Those are organizations which are publishing large volumes of data in the public sector, processing large volumes of data in a public area, in other words, large volumes of CCTV data or similar types of data, and processing large volumes of special categories of data, and where this processing is a core activity of the business. So an NHS trust, for instance, will definitely have to have a DPO. Anybody operating large-scale CCTV facilities or vehicle tracking facilities will need to have a DPO. So if you need a DPO, appoint one. If you don't, consider the sense of appointing one or appointing somebody who can deal with your GDPR compliance. It's a complex and onerous program, and the opportunities for getting into trouble are big. Decide what's in scope, which parts of the business are in scope, which territories, which suppliers might you want to exercise some control over. What management systems do you already have in place that you could bend to your GDPR compliance projects? ISO 9001, which deals with processes, and many of those processes will be dealing with personal data. ISO 27001, which deals with information security. Data protection is part of information security. So what standards can your clients bend to their project? And where are the processes which are currently underway which might trigger the need for a data protection impact assessment, the starting point for what we call data protection by design and by default. And quite often, one of your key interfaces with clients will be designing or working with them to implement new processes and systems. And any new IT-enabled process or system is likely to require, by law, a data protection impact assessment, which your client should be carrying out with your input in order to make sure they've identified the most appropriate controls to put in place to protect that data. There is a detailed compliance guide that you can sell to your clients. You can get them to buy off of our website. That's the GDPR Compliance and Implementation Guide. We have foundation and practitioner training courses. You can have clients go and do the foundation course or the foundation and practitioner. There's special pricing if you're doing both foundation and practitioner. That's really the cornerstone of GDPR training. We've trained something like 10,000 people on GDPR over the course of the last 12 or 18 months. So there's a significant body of knowledge and understanding around GDPR implementation. And there's a DPO as a service. More and more organizations that have to have a DPO are recognizing the value of having this as an externally provided service. Externally provided service means that you're paying only for what you need rather than for a full-time employee. And you can rely on the fact that the DPO you're getting will be continuously kept up to date and will be continuously available. Your DPO as an individual never goes on holiday because it's a corporate service, so you're always able to access what you need in the way of a DPO as you go at a price which is much more affordable. And DPO as a service is, again, specifically allowed for in GDPR and something that you can easily sell to your customers. Step two, continuing the business of preparation. If you're appointing your own DPO, you can put them on certified DPO training. You can then take advantage of both the DPO support service for a DPO or a GDPR data privacy managed service. The data privacy manager service really is designed for those organizations that don't need a DPO, but do want somebody who's going to look after data and handle that part of their activity effectively. So there will be another webinar which talks about the range of services that come from the group company, GRCI Law Limited. We'll give you more details about each of those, but you can certainly start talking to customers about them right now. Third step is the data inventory and data flow audit, getting the project underway. The data flow or data flow mapping exercise, you'd use something like a data flow mapping tool, which again, you can sell on a subscription basis to customers customers, it's affordable, relatively straightforward to use, is a very effective way for clients to meet their GDPR Article 30 obligation to keep a record of the processing they're doing. Above all, what it does is identifies where data is being processed in a way that enables the organization to determine what appropriate measures are to protect that data. So you should, your client should be mapping the data flows through the organization and determining whether a DPIA is needed or not. As I said, you can either buy the, have a client buy the data flow mapping tool, or you can sell to them a data flow mapping service where IT governance consultants will go on site and use the tool to carry out a data flow audit for the client. Detailed gap analysis would be the logical next step, and that's where you're starting to look at the detail of the documentation, identifying where there are gaps in documentation and security. You would be looking to find out all of the things you still need to do that will bring you up to compliance with the GDPR, give you your remediation plan. The two tools or services you can use for those of your clients who want to do it themselves, so to speak, there is the compliance gap assessment tool, nice straightforward tool to use that tells an organization pretty well exactly where they are and what they need to be doing to bring themselves up to compliance. Or again, you can arrange for an IT governance consultant or consultants to go on site and to carry out the assessment. We've probably done 500 or 600 of those over the course of the last 6 to 9 months. We saw mostly organizations tackling the GDPR compliance gap analysis step in the more recent period rather than over the full 2 years. So we have very substantial experience in putting together a report which is really useful to organizations to tell them what it is they need to do to be able to get themselves compliant. Step 5 is to do the detailed work around operational policies and procedures, the setting out of the requirements on staff for how you want them to operate, the standards to which you want them to operate, making sure that the documentation, the data flow map that was created in the earlier stage becomes a complete Article 30 record of personal data processing activities. Make sure you've got appropriate data protection policies and privacy notices. You'll find many organizations think that simply having a privacy policy or a privacy notice on their website, they've done the job. They really haven't. That's just one of a number of critical documents. Dealing with all the issues around lawful basis for processing data. You will have seen in the run-up to May the 25th, many organizations thought they needed to get consent from everybody on their mailing list to continue marketing to them. In fact, they probably didn't. In many cases, they might have had some other lawful basis to continue the relationship. They didn't need to rely on consent. And the whole issue around the lawful basis for processing of data, whether it's consent, legitimate interest, or in order to fill a contract or 2 or 3 others, is a key bit of compliance activity for all organizations. If you get that bit wrong, you'll be processing data illegally, and that means you've got to stop. So you need to get it right. You need to review employee, contractor, clients, and everybody else's contracts to make sure they deal appropriately with data lawfully and legally. You need to work out how to deal with data subject access requests and determine whether or not a DPIA is required. So those are all areas that you can help your clients address by drawing on the possibility of selling, for instance, the GDPR documentation toolkit. We sold several thousand of those. You can deploy DPIA workshops into your clients where we can teach clients how to do data protection impact assessments. We can deploy clients to come and work with, we can deploy consultants to come and work with your clients around how to implement the documentation. So step 5, very big part of the project because it's putting in place all of the documentation that you specifically need. You can also buy, if clients have got quite a lot of documents, they just need a few, you can buy individual GDPR templates, or you can, as I said, arrange for either our consultants to help you more generally, or you can arrange to pull in, again, through your channel partner the specialist lawyers from GRCI Law, and they can come on site. They can give you very specific legal advice around all of the issues on which you want legal advice. So while our consultancy team is usually lawyers by background, but we're providing practitioner advice, so not legal advice, and the law team can come and give you the very specific legal advice that you need around specific issues in a way that you can legally rely on it. And as I said earlier on, there will be an upcoming webinar which will deal with the offering from GRCI. Step 6 then is the steps to secure personal data. Data Protection Principle 6 says that data has to be secured. Article 32 says data has to be secured. Breach of the first is a 4% fine. Breach of the second is a 2% fine. So how that's going to pan out in reality, we don't know. But you certainly need to have an information security policy in place. You definitely need to have basic technical controls like Cyber Essentials or Cyber Essentials Plus in place. It's why we encourage all of our channel partners to at least do Cyber Essentials, if not Cyber Essentials Plus. And you should be encouraging all your customers as a simple basic measure to do Cyber Essentials. It's a very easy product to sell. It's a low-cost product for most small and medium organizations. It gives them a baseline level of simple security. It deals with something like 80% of the internet-borne threats, and that's frankly where most small and medium organizations need to be worrying. It's the automated internet-borne threats that are the issue. Cyber Essentials Plus will give them a level of assurance about the extent to which they have those under control. So as I said, you really should be making sure every single one of your clients, as a matter of standard activity, is Cyber Essentials Plus certified. And as you almost certainly know, you can use the existing IT governance portal and manage your clients through that. Encryption may be a logical thing for clients to be doing. Encryption is a way that organizations can ensure that even if they do have a breach, data can't be accessed. And as I said, you need to have in place a proper process. Your clients need to have in place a proper process to investigate data breaches. Quite often they'll be asking you to help them with those because you manage to one extent or another their IT and technology. So you need to think about how you're going to formalize what you do around data breaches so that you can very easily interface with what your clients are likely to look for. Sensible data breach management programs are prepared well in advance of a breach so that they're tried and tested. You know who has to escalate what to whom. And if you can push that out through your clients, if they have a breach, they know exactly how you're going to help them well in advance. That would be a very smart thing to do. As I said, Cyber Essentials is one of the essential products you should be deploying, but there are others that are part of helping clients get to the point they can manage security and manage data breaches. Incident Response Management Training course, that's a practical training course for you and for clients to go on because it teaches you how to work out what you want to do around incident response. Penetration testing you should be deploying in across almost all of your clients almost all of the time. So if you look again at the British Airways breach, in a period of just 2 weeks, they had 15 days, they had 380,000 customer records stolen. If you're only doing a penetration test once a year, you haven't got a chance of picking that up. You need to be penetration testing, and you should be talking to clients about running penetration tests on them quarterly, at the very least, for higher value clients, maybe more often than that, because that's the one way, both on websites and with internet-facing infrastructure, you can be sure that they have got an appropriate level of security in place, that you've identified and been able to mitigate vulnerabilities. We've made penetration testing quite simple. There are 2 levels of penetration testing, level 1 and level 2. And in most cases, for your small and medium clients, level 1 penetration testing will be completely adequate. And level 2 penetration test is a more complex test designed for organizations that are likely to be a specific target for hackers and need more work done to make sure that vulnerabilities are tested to a greater and wider range. So most organizations, level 1 penetration test, cost effective, quick to deploy, should be done on a regular basis. You think of Cyber Essentials and penetration testing is two of the things that all of your customers should, as a matter of course, do all of the time, you've made a big step towards getting them operationally secure. If you also say to them, you have to have a proper privacy notice, you have to have an Article 30 set of records, you have to have an incident reporting process, you've probably got them to the point where they're going to deal with 60 or 70% of the problems that come their way. They're not going to be GDPR compliant, but they'll be 60, 70% of the way there. And if you can get them there, closing the rest of the gap may be quite a lot simpler. Step 7 then is about communication. Communication, because GDPR is really a business change project. It's going to affect people throughout throughout your client's organization. They need to be talking, you need to be talking to them so that employees understand why that matters. You as the service provider need to be helping them enforce good password practices, proper data protection behaviors, proper GDPR basic principles. You need to be helping them put all of those kinds of things in place. And you might use staff awareness training courses to do that. Very straightforward to deploy GDPR staff awareness e-learning, but you could also offer to your clients both the phishing awareness training. Something like 70% of successful external attacks right now are through organizations, through hackers successfully phishing and hooking somebody inside the target organization. So staff awareness and phishing training, very good training courses to be able to sell. And there's also growing incidents of people misusing the CC field in an email when they're meant to use BCC, as a result of which thousands or hundreds of people learn who else is on the list about a subject which is potentially very sensitive. Certainly their personal information has been shared because everybody can see their email address, and of course email address is personal data. So another piece of e-learning which you could easily deploy into your clients. And you might think about staff awareness e-learning as one of the things which in the longer term project management relationship or account management relationship with your clients, you're offering to them as part of the broadening of the range of services which you have for them in their compliance program. And then, of course, as I said, GDPR is a journey, not a destination. So you need to be thinking about what comes next. We've got you compliant now. How do we keep you there? And your clients should be thinking about buying GDPR audit services, ongoing audits of their compliance, but also ongoing audits of their suppliers' activity. Wherever they've got processors who are processing data, they'll want to make sure that the processes there are themselves compliant. DPIAs will keep on coming up as the necessary step to do. So again, DPIA service, our ongoing audit service, the live online GDPR consultancy, all of those are essential products to help organizations deal with the ongoing continual improvement of their GDPR compliance. Remember, the nature of threats are going to change. The reality of what the law really means will become clearer with court cases. So monitor, audit, and continually improve is a key part of organizational resilience. Let me talk a little bit about resilience because properly speaking, most organizations don't really understand all of the detailed ways in which the data they process might be at risk. They think that often data breaches are caused only by cybersecurity instances, but they're not. The reality is that all organizations are at risk, and they're at risk because they probably employ some people. And people make errors. The most common types of data security incidents, and all of these are incidents which potentially will have to be reported to the ICO as a data breach, is data which is posted or faxed to one or typically a number of incorrect recipients. So if you send out a fax to 25 people about somebody's particular health problems, and you only meant to send it to one, but you picked the wrong mailing list, you've got a data breach. Loss or theft of paperwork. Remember that paper in a filing system is going to be subject to GDPR. It's intended to be part of a structured filing system, or is, therefore it's subject to GDPR. And loss of a personnel file or a series of personnel files, or exposure of salary record or a salary rec, all of those again are going to be data breaches. Data sent by email to incorrect recipients, failure to redact data when you're responding to a data subject access request, failure to use BCC rather than CC when you're trying to deal with a number of people. All of those are human error-based data breaches. And as I said, something like 70% of the attacks are successful because, again, they exploit human weakness. They get a human being to click on a link in a phishing email that really they shouldn't be clicking on. So when you're thinking about security measures, you really do have to be thinking quite hard about how do we deal with people and process, not just how do we deal with technology. That's why, from a practical point of view, your partnership with IT governance is an effective one. You guys are already on top of all of the technology aspects of the cybersecurity relationship. What we're able to give you are the tools that enable you to add people and process to that technology relationship in a way that enables you to give a complete package to clients in terms of dealing with the mostly automated rather than targeted attacks that are looking for vulnerabilities in networks and which typically will exploit those vulnerabilities themselves in an automated way. For big organizations, yes, attacks might be specific and targeted, but for most organizations, they're just simply looking for vulnerabilities, human weaknesses or technology weaknesses, process weaknesses, which can be exploited by attackers at a distance. So building up resilience is about making sure that as an organization you can cope with all of those. And that's about building an increasing level of protection, starting with basic security practices, looking at cyber essentials, and then building policies and procedures, audits, and so on in such a way that as an organization you get a depth of compliance. Resilience reflects itself in how well your clients can report a breach to the ICO. So if you have a data breach, and unless the data is encrypted, or another way, unless you're able to conclude that there is no risk to the rights and freedoms of data subjects as a result of the data breach, you have to report the data breach to the Information Commissioner. And you've got 72 hours from discovering the breach to reporting it. Of course, if the breach has been taking place for a long period of time, there's going to be a question around your negligence and the fact that you failed to identify there had been a breach. So if you're an organization that found out there was a breach 2 years ago and has been in place for the last 2 years, you've got a much bigger problem, but you still need, the moment you report, to know you've got 72 hours to report it. And when you report it, you've basically got to say, this is what the breach was, how it was carried out, how extensive the breach is, who did it, what data has been affected, how the compromise, the extent of the compromise of the data. It's a very comprehensive form that you have to fill in, standardized form that you fill in on the ICO's website. And it ends up with questions like, what training did the person who was, or the people who were involved in this breach have in the 2 years prior to the breach occurring? And what could you have done differently prior to the breach occurring that might have caused the breach not to happen? So those are two key questions that your clients are going to have to answer when they're dealing with a breach. You don't want them saying, well, we didn't get around to providing any training, or the training that we gave people was inappropriate. And yes, there were things that we could have done to avoid the breach, but we didn't do it. We could have put an accountability framework in place. We could have penetration tested. We could have done a whole bunch of stuff. You do not want to be saying any of that. You want to have your clients able to deal properly and completely with data breaches. So in your 72 hours, you're going to respond with as much detail as you can. You're going to go back maybe later on as you get more data in, you're going to finish the reporting format. And the ICO will use the information that you provide to decide what happens next. And that might include carrying out an investigation, might lead to regulatory action, could lead to a fine. They might decide there's nothing more they wish to do because you've contained it and dealt with it, and they might simply use the data to help identify security trends. But the report to the ICO, you have to think of as the starting point in a process rather than the end point in a process. So In our data breach reporting campaign, and for many of your organizations who might think of themselves as being sort of GDPR ready, but they're worried about whether they can report a breach or not, we've created a pick and mix set of products and services that you can offer to your clients in a way that enables them to pick the things that they need to deal with the areas where their breach resilience might be inadequate. So they cover the situational analysis around a breach, assessing the data that's been affected, describing the impact on the organization, reporting on staff training, the preventive measures that could have or should have been taken, and how oversight works. Those are the steps, that the 6 areas that you're reporting in are broken down to. And I'm just going to talk you very briefly through the implications of each of those from a reporting point of view. So the first is situational analysis. Do you know what happened is the key question that you're going to be trying to answer here. Do you understand the incident that occurred, that disasters happened? What was it that took place? Did you have people in place ready to deal with it? Had someone been trained in responding to incidents? Was there a reporting process that means the incident got reported to the right person, it got escalated to somebody who could deal with it? Do we have the right setup in place? And you can, for those organizations thinking about it, you can be offering them both cyber incident response management services, and you can offer them certified information risk management foundational training. Simple 2 sets of logical products that you can deploy to help your clients be ready around step 1 of reporting a breach. Being ready to report step 2 of a breach really means you need to have done some work before the breach happens, because this is about assessing what data has been affected. The questions here really are what categories of data have been affected and how many records. That means you genuinely need to know what data is being held. What does the client have on their systems? Where is it? How old is it? How is it protected? Those are very important questions. And really the only way you can do that is through a data flow audit, irrespective of whether the client carries out the data flow audit themselves using a data flow audit tool, or you use the data flow audit service that you can get through your account manager. Either way, the only way to be in a position to deal with this set of questions is a data flow audit. The other thing a data flow audit is doing is giving you evidence that you've complied with the obligation in Article 30 to create a record of your data processing. Not having a record of data processing itself can trigger a fine of up to 2% of global turnover. Step 3 is describing the impact. And it's not the impact on you, the organization. This is about the impact on the data subjects. Remember that GDPR is fundamentally about protecting the rights and freedoms of data subjects. And therefore, when looking at a breach, all GDPR is concerned about is the impact on the data subjects. The best way of doing this is a comprehensive information security risk assessment. To do that in a way that's repeatable and dependable, you'd want to use a tool like VS Risk. VS Risk is a software tool. It's available on the desktop right now. It'll be available in the cloud from October, and it's a tool which you can sell to your clients and will help them effectively carry out a risk assessment and have the basis for later risk assessments, because they'll want to be able to review and update, and that means having the risk assessment in a format that they can use is a good way to do it. It can significantly cut costs, significantly reduce errors, and it's a very standard part for most organizations now of managing information security risk. Step 4 in data breach reporting is the questions around staff training and awareness. And given the widespread recognition that the biggest weakness most organizations have is around staff, and given that staff are handling personal data all the time, absence of staff training is always going to be treated by the ICO as evidence of negligence to one extent or another. So the answer to the question, if a staff member was involved in the breach, had they received data protection training? Do they know how to determine whether a breach has occurred, what the appropriate steps are? All of those are areas that your clients really do need to have dealt with long before a breach occurs. So you should be using that simple requirement to deploy e-learning into all of your clients. Staff awareness training, and you could either deploy that on a client-by-client basis, or you could probably arrange to put together an offering for all of your clients, but there are a number of different ways we could help you structure the delivery of staff awareness training into your clients. And whether it's GDPR staff awareness or information security awareness, or it's the human patch courses around how to use CC fields or how to spot phishing emails, or if it's the combination of foundation practitioner certified DPO training that's appropriate to ensure that your clients have got the necessary skills and competences inside the organization. Those are certainly going to be elements of how you go about ensuring that the organization can deal effectively with answering these questions. And then there is the fifth step, preventive measures. Describe the actions you've taken or proposed to take as a result of the breach. You've got to work that out, really, if you're going to try and look as though you know what you're talking about in the 72 hours when you're reporting. And remember, for most organizations, the 72 hours when you're reporting a breach is over the weekend. BA were lucky that they identified the breach on a Wednesday. Most breaches are identified on a Friday sometime, and that's because that's when breaches preferably happen. Attackers, if they're going to attack you, prefer a Friday, because then they get the weekend mostly to exploit the attack. So your clients need to be in a position to work out what the preventive measures are. And one way of dealing with that is, first of all, to have put Cyber Essentials in place. Cyber Essentials or Cyber Essentials Plus means that there are a number of breaches which cannot take place, which will not take place, because you've got the right anti-malware software, you've got the right firewalls, you've got that kind of basic protection in place to protect the organization. Penetration testing, again, means that you will have identified most of the vulnerabilities on your websites and your internet-facing equipment, your client's internet-facing equipment. Of course, all of this is likely to be your infrastructure as an IT organization, and so you testing it on a regular basis and demonstrating to clients that it is safe might be part of a value-added service that you can offer to your clients. Increasingly, though, we see organizations stepping towards ISO 27001 as being the effective way to build a management system which demonstrates that you've got an appropriate level of information security in place. There are now some 40,000 organizations globally which have an ISO 27001 management system certificate. We expect that that will grow to some in the order of 1 million over the next 7 to 10 years. And it's a sensible way, therefore, for you and your clients to be putting in place something that demonstrates that you're genuinely compliant. Nielsen, a UK company, is being an action is being brought against them in the US courts by a UK citizen who's a shareholder in the US, who says that Nielsen claiming that it was GDPR compliant when in fact it wasn't, meant that there was an inflated share price, as a result of which he lost some money, and he's seeking to bring a class action lawsuit against Nielsen, its CEO and its CFO, for claiming to be GDPR compliant when in fact they were not. We expect to see more of that appear. Many organizations are claiming to be GDPR compliant when in fact they're not. The only way you can demonstrate you've got something that looks like GDPR compliance is by implementing an externally certified management system, which is made up of a combination of ISO 27001 and the new British standard BS 10012. Those put together give you what's called a privacy compliance framework. You can have that externally audited. You can have a certificate. For an example, look on our website. That's what we've done. And it's a form of assurance that says that our claim to be GDPR compliant is supported by an external objective assessment against an international standard. It's not just management saying so. So those are measures that you should be thinking about, both as existing preventive measures and the kind of actions that organizations concerned about a breach could be taking. And finally, oversight. GDPR requires the identification of a DPO, as I've said, for a number of types of organizations. The ICO, when you're dealing with a breach, would expect you to have identified a senior responsible person for managing that breach, a senior responsible person somewhere inside the organization to manage that breach. And this is a real challenge for organizations, given the breadth of issues that the data protection officer has to be able to deal with. DPO as a service, as I mentioned earlier, is a practical and cost-effective solution for organizations to fulfill their DPO obligations under the GDPR. And the DPO service that we offer obviously includes a breach reporting service. We'll be launching a standalone breach reporting service relatively soon. You'll be able to offer either or both of those to your clients. Breach reporting is as a service is a very good way of signing clients up to an annual subscription, which means that they're going to continually be able to turn when they have a breach to us, knowing that we're going to help them deal with it appropriately. We've seen from those of our clients who have GDPR data protection officer as a service, they range from small to very large. On average, they're dealing with at the moment 2 data breaches a month, at least one of which is likely to be reportable. So our view is that organizations that don't have DPOs of some description and are not paying attention are likely to be having breaches occurring which they're not identifying, not reporting, and that's fine until somebody whose data is breached reports you, as a result of which you get investigated by the ICO, and the ICO discovers there have been 3, 4, 5 breaches, none of which have been reported in the past. And that means the potential fines are that much bigger. So for the breach reporting campaign, Are You Breach Ready, which we're running all the way through summer, there are 3 what we call security protection factor, sun protection factor packages, and you can take a mix and match of the range of products available, and depending on the size of the purchase, you can get a discount, or your client can get a discount off those purchases. You as a channel partner, you're going to get your channel discount off those as well. But that's the public offer, and so it's a really worthwhile offer that you can take to clients because it helps them draw on a range of products and services which helps them get themselves into a much better place in terms of GDPR compliance. And that, ladies and gentlemen, brings me to the end of what I was planning to say today. Your account manager or your account manager partners at IT Governance, or the direct email address for your account manager, you'll be able to talk to them about the range of offers we have there. I'm sure they'll want to follow up with you over the course of the next few days. We're certainly keen to work with you, not just through this webinar series, and there are more webinars coming up, but keen to work with you as you take this range of products and services to your clients and broaden out your offer to them in a way which enables you to much more effectively help your clients deal with the whole process, people, and technology domains of cybersecurity and GDPR compliance. So, as I said, that brings me to the end of what I was planning to say. Happy to take questions. If you have questions, please do use the question functionality in GoToWebinar. What I'll do is I'll read out any questions there are, and then I'll answer the questions. And when we're done, we're done. So far, one question is, what are the likely costs of DPO as a service? Can a client acquire DPO as a service on a retainer monthly basis, and what does the partner get? Taking the middle question first, yes, the client can acquire DPO as a service on a retainer, can pay for it on a monthly basis. Typically, the clients prefer taking it on an annual basis because they prefer the value, they prefer the discount that comes with paying for it annually in advance, but you can pay for it monthly. The partner will get whatever the partner discount is, whatever your partnership level is, you'll get that on the DPO service. Typically for the average organization, DPO as a service is about £14,500 to £17,500 a year. And typically that covers the core DPO services. So it starts with making sure you're GDPR compliant, making sure there's a program in place. Of course, if you need more help to get there, then the DPO would tell you, and your client would need to go and get the support they needed to do that. So DPO as a service might lead them to buy more stuff from IT Governance. would deal with data subject access requests, would deal with data breaches, would deal with any of the ICO interactions that there might be, would deal with any of the other regulatory requirements that a data protection officer might have, would provide regular updates and advice on changes to the law or regulation, would meet with management on a regular basis to make sure that they're continuing to be aware of how they're performing in terms of GDPR compliance. As I said, the GRCI, this is often run by the GRCI law company specifically, would, in the webinar series we have coming up, you'll be able to talk to them very much more directly around everything involved in that and the other GRCI law services. So I think that deals with that question. Any other questions, folks, that you have for me today? All right, looks as though probably not. I hope that means that I've been sufficiently clear, not just that everybody's passed out. Groucho Marx is said to have reported after watching a cricket match for the first time, what a wonderful cure for insomnia. I hope that's not what my webinars are. Folks, I hope this has been useful. Please do go back to your account managers. Do talk to them about ways in which we can help you help your clients meet their GDPR and broader cybersecurity obligations, and the way in which we can particularly help your clients take advantage of the breach ready campaign which we have running at the moment. Thank you all for your time, and good luck.